Breaking today, the Supreme Court of the United States issued a 6-3 decision that could dramatically reshape the future of so-called assault weapon bans across the United States. If you are already seeing headlines spreading quickly across social media, take a moment to slow down, because what just happened is significant. Not symbolically significant, not incrementally significant, potentially structural, constitutional, and long-lasting. But as always, the details are what matter most, and the way this ruling connects to the latest move by the United States Department of Justice may be even more important than the vote count itself. So here is the central question today. Did the Supreme Court just open the door to permanently ending assault weapon bans nationwide? That is what many voices are claiming. Others strongly disagree. And as usual, the real answer lies entirely in the legal reasoning behind the decision. Before we go deeper, if you value clear and straightforward explanations of complex constitutional developments like this, make sure you are subscribed. These cases evolve quickly. Headlines move even faster. Even faster. What matters most is understanding what the court actually said, not what activists on either side wish it had said. In this 6-3 ruling, the court reaffirmed and strengthened the framework first established in the landmark case commonly known as Bruen. That decision set the rule that when courts evaluate firearm regulations, they must rely on the text of the Second Amendment and the historical tradition of firearm regulation at the time of the founding. Nothing else. No modern interest balancing. No judicial weighing of government safety concerns against constitutional protections. In today's opinion, the court made it unmistakably clear that lower courts cannot avoid that standard by repackaging older balancing tests using new historical terminology. This point carries enormous weight. For years, lower courts, particularly within the United States Court of Appeals for the Ninth Circuit and the United States Court of Appeals for the Fourth Circuit, have upheld assault weapon bans by arguing that certain rifles are a military style or unusually dangerous. TIS Court of Appeals. The Supreme Court did not directly strike down every pending rifle case by name. However, what it did accomplish was closing the legal workaround that those courts had been using. In many ways, that is even more consequential than issuing one targeted ruling. The majority opinion emphasized that firearms commonly possessed by law-abiding citizens for lawful purposes fall within the protection of the Second Amendment. This is where the analysis becomes especially important. The court repeated language from its earlier precedent stating that arms in common use are protected. Consider what that phrase means. 15-style rifles are owned by an estimated 24 to 30 million Americans. They are among the most widely owned rifles in the country and are used for home defense, recreational shooting, competitive events, and hunting across numerous states. Lower courts have attempted to remove these firearms from constitutional protection by labeling them weapons of war or unusually dangerous military tools. But today's decision strongly signals that widespread lawful ownership carries far greater constitutional relevance than aesthetic features or political labels assigned by lawmakers or judges. For years, the more liberal wing of the court, and at times several cautious justices, avoided directly addressing the assault weapon issue. Their reasoning often leaned on arguments about technological evolution and dangerousness. But the current 6-3 alignment signals something fundamentally different. This is not a narrow one-vote margin. It is a stable constitutional majority that has grown increasingly frustrated with lower courts that reinterpret or sidestep Supreme Court precedent. Today's decision makes that type of reasoning significantly harder to sustain. Meanwhile, in California, federal judge Roger B. Nitez has repeatedly ruled that the state's magazine ban is unconstitutional, only to be reversed by appellate panels that declined to fully apply the same framework. That repeated cycle of lower court resistance is precisely what the Supreme Court appears to be addressing with the stronger language issued today. The DOJ has also filed statements of interest in magazine capacity cases, arguing that arbitrary round limits may infringe upon protected arms. And this issue matters greatly because a standard capacity magazine is a functional component of many commonly owned rifles. Justice Samuel Alito has recently noted that some lower courts are treating the Second Amendment as a second-class right. The DOJ's new litigation posture appears to be a direct institutional response to that concern, reminding federal courts that Supreme Court precedent must be applied consistently. So what happens next? What are the realistic paths forward from this moment? One possible path is that the Supreme Court grants certiorari in one of the pending cases, schedules oral arguments, and then issues a definitive ruling either this term or the next. That would place the country on a direct timeline toward the most consequential Second Amendment. Clarification, since the modern framework first began taking shape. Another possibility is a GVR order, grant, vacate, and remand, where the court sends the pending assault weapon cases back to lower courts with explicit instructions to reconsider them under today's strengthened standard. That approach allows the court to apply pressure without immediately issuing a sweeping national opinion. However, there is real risk in an incremental approach, and the court is well aware of it. Some lower courts have already demonstrated a willingness to resist the historical framework by relabeling interest, balancing as historical interpretation, while still reaching the same regulatory outcomes. If that pattern continues after today's stronger guidance, the Supreme Court may conclude that indirect instruction is no longer sufficient and that direct constitutional clarity is necessary. With the federal government now aligned with the plaintiffs in multiple cases, one of the court's traditional institutional concerns, whether the government's regulatory interests are fully represented, has effectively disappeared. Federal attorneys are now presenting data indicating that these rifles are overwhelmingly selected by Americans for lawful purposes. That shift makes it far more difficult for lower courts to argue that such firearms are unusual. Now let's examine what a definitive ruling would actually mean in practical terms, because this is where constitutional theory becomes real-world impact for millions of Americans. If the Supreme Court ultimately rules that commonly owned semi-automatic rifles cannot be categorically banned, existing state bans would immediately face serious constitutional challenges. Enforcement in several jurisdictions could be halted through emergency injunctions. Pending prosecutions based solely on possession of restricted firearms could be dismissed or reopened. State legislatures would likely need to reevaluate their regulatory structures from the ground up. Importantly, the implications would not stop at the state level. A clear ruling that commonly owned rifles are protected arms would apply equally to federal legislation. Any future federal assault weapon ban would face the same constitutional analysis and would likely be evaluated under the same historical standard. That does not eliminate the broader policy debate. Instead, it shifts the debate away from whether entire categories of firearms can be banned and toward how regulations can operate within constitutional limits. That distinction fundamentally reshapes the legal landscape. It is also important to clarify what such a ruling would not do, because misunderstanding this point often creates unnecessary confusion. A ruling against categorical assault weapon bans would not eliminate all firearm regulation in the United States. Background checks would still exist. Licensing requirements would still apply. Age-based restrictions would remain in place. Regulations concerning how firearms may be carried would continue to be evaluated under the same historical framework. What would change is the specific practice of banning a firearm outright based solely on certain physical characteristics, when that firearm is already owned lawfully by tens of millions of citizens. The constitutional boundary is not between regulation and no regulation. It is between permissible regulation and categorical prohibition of commonly owned arms. There is also an argument frequently raised by those defending these bans, and it deserves careful examination. The argument states that even if certain rifles are widely owned, the government still has a compelling interest in restricting them because of the potential scale of harm they could enable. It is an emotionally powerful position, but under the current legal structure, it is not the controlling test. And in the controlling test, the historical framework does not ask whether a regulation is supported by modern policy concerns. Instead, it asks whether that regulation aligns with historical traditions of firearm regulation from the founding period. Historical records do not show categorical bans on commonly owned firearms. Early regulations focused primarily on how and where arms could be carried, not on eliminating entire classes of weapons in widespread lawful use. That distinction forms the legal pressure point for many modern bans. The dissenting justices emphasized technological evolution, arguing that the founders could not have anticipated the destructive capacity of modern semi-automatic firearms. It is a serious argument grounded in modern public safety concerns. The majority rejected that reasoning based on a broader constitutional principle. Rights do not diminish simply because technology changes. The First Amendment applies to communication on the Internet, even though such technology did not exist at the founding. The Fourth Amendment applies to digital searches even though digital data was unimaginable in the 18th century. The majority applied the same interpretive consistency to the Second Amendment. There is also a practical dimension that affects millions of ordinary Americans living under current restrictions. In several states, owning a rifle with specific features can result in criminal penalties. Individuals have faced prosecution. Businesses have closed. Law-abiding citizens have encountered legal consequences for possessing firearms that are widely owned elsewhere in the country. Regardless of where one stands in the policy debate, those outcomes carry real consequences for real people. If the Supreme Court ultimately issues a definitive constitutional ruling on this issue, those legal outcomes could change immediately. Today's decision, combined with the federal government's new litigation posture, represents a convergence of legal forces not seen before in modern Second Amendment cases. The doctrinal framework is tightening. The majority alignment appears stable. Federal litigation strategy has shifted. Lower court workarounds are being addressed, and the cases most likely to serve as final vehicles are already moving through the judicial pipeline. Whether the final ruling arrives this term or the next, the direction of the legal trajectory has become clearer than at any point in recent years. Another strategic question now emerges. Which case ultimately becomes the vehicle for the court's final answer? One option is a case from Maryland, where appellate reasoning has drawn intense scrutiny. Another option is a case from California, where the cycle of lower court rulings and reversals has continued for years. A third possibility is that the court consolidates multiple cases into a single proceeding that addresses rifles, magazines, and related regulatory features simultaneously. Each path carries different consequences for scope and clarity. A consolidated approach could produce a broader ruling, but would require a more complex opinion. A single case approach would likely move faster, but could leave additional questions requiring future litigation. Recent patterns of repeated relisting of petitions suggest that the justices are carefully evaluating which case provides the cleanest legal record and the strongest factual foundation for a durable constitutional ruling, one that cannot easily be distinguished or bypassed by lower courts in the velour courts in the future. There is also the question of timing and what the conclusion of the current Supreme Court term means in practical terms. Traditionally, the court releases its most consequential rulings toward the end of the term in late June. If certiorari is granted in one of these pending cases before the end of the current cycle, oral arguments would likely take place during the fall session, placing a final decision on track for June of next year. If instead the court chooses to issue GVR orders and observe how lower courts respond, a definitive ruling could arrive one full term later. For gun rights litigants and constitutional advocates, this process has already stretched across multiple legal cycles. With the combination of developments present right now, the strengthened doctrinal framework, the shift in federal litigation strategy, the existing cases already positioned for review, and the stable 6-3 majority, makes the coming 12 months one of the most consequential periods since the court's modern Second Amendment jurisprudence began taking shape. There is one final dimension that deserves attention as we close this analysis, and it extends beyond the immediate firearm policy debate. For many years, the Second Amendment discussion has often been treated as a specialized legal issue, important within policy circles, but somewhat peripheral to the broader constitutional conversation. What is unfolding now suggests something larger. The court is in the process of reinforcing the principle that the Second Amendment functions as a first-class constitutional right, subject to the same rigorous protection applied to other core liberties. That includes the standards traditionally associated with the First Amendment and the Fourth Amendment, rights that courts consistently evaluate through structured constitutional analysis, rather than shifting policy preferences. Once firmly established through a clear and definitive ruling, that methodology will influence far more than a single category of firearms. It will shape how courts evaluate the entire structure of firearm regulation moving forward. That is precisely why constitutional scholars, policy analysts, and legal practitioners across the political spectrum are closely watching these cases. Moments like this, when interpretive frameworks become settled, tend to influence legal outcomes for decades. Another strategic consideration involves which specific case ultimately provides the strongest foundation for the court to issue its final ruling. One path would involve selecting a case with the most direct constitutional conflict. Another path would involve choosing a case with the most developed factual record. A third possibility would involve consolidating multiple cases into a single comprehensive decision, addressing rifles, magazines, and related regulatory questions simultaneously. Each option carries trade-offs between clarity, scope, and durability. A broader ruling could resolve multiple issues at once, but would require more complex legal drafting. For legal draft, a narrower ruling could be issued more quickly, but might leave certain questions unresolved. Recent procedural patterns, particularly repeated relisting of petitions, suggest that the justices are carefully working through these strategic considerations, evaluating which case structure will allow them to produce the most stable and clearly applicable constitutional guidance. There is also the practical reality tied to the court's internal timeline. If certiorari is granted soon, oral arguments would likely occur during the fall session, placing a final decision within the next annual cycle. If the court instead prefers incremental procedural steps, the final resolution could extend further into the future. Even so, the structural alignment of legal factors currently in place makes the upcoming window uniquely important. The strengthened interpretive standard, the evolving litigation posture of the federal government, the existing appellate conflicts, and the stable majority configuration together create a legal environment that has not existed in previous cycles. For individuals and organizations tracking constitutional developments, this period represents a turning point. The debate itself will continue. Policy discussions will remain active. Legislative proposals will still be introduced. But the constitutional framework guiding those discussions appears to be moving toward a more clearly defined structure. And that clarity, once fully established, will influence how courts, lawmakers, and litigants approach the issue for generations. If you want to stay updated on every order list, every conference development, and every new filing connected to these cases, make sure you are subscribed. The next several months could bring decisions that reshape the constitutional landscape in lasting ways. When the next major procedural update arrives, we will break it down clearly and directly, without spin, without noise, focused only on what the legal developments actually mean. Because moments like this demand clarity. That's exactly what this channel is here to provide.